Okay? So malfeasance. Mal meaning bad, feasance meaning like a thing, right? You're taking an action. You're lying about it. Okay? Now, Eduardo, let me ask you the follow-up question, right? What happens if I never ask you about the roof? It never comes up, right? And you just sit there and stay quiet. Have you done anything wrong?
No, because you told me I don't have a...
Exactly. Okay? So malfeasance is lying, right? What Eduardo just said was nonfeasance, which is staying quiet. So under the common law, there's a big difference between lying and staying quiet. I'm sure everyone's had this, right? You know something, and you don't want to tell them. You're saying, oh, please don't ask me about it. Please don't ask me about it. Because they ask you about it, you have to lie. And if they don't ask you about it, you can just stay quiet, right? So historically, under the common law, malfeasance was a no-no. You could actually rescind a contract if there's malfeasance. But if there's nonfeasance, you know, you have to ask questions, right? This is why, again, you have these very long forms that ask you about everything. This way you can't be accused of failing to ask the right questions, right? By making the seller check off on every single conceivable problem, it's impossible to be staying quiet. Understand that, right? By having a 30-item contract that asks the seller about everything, he can't play dumb. Eventually, he's going to have to say, oh, well, they asked me if there's any termites on this thing, so I have to check it off. Oh, they asked me about lead paint, I have to check this off. Oh, there's a question about structural damage. Damn it, they asked me, I have to check it off, right? So those long forms were meant to protect the sellers, right, so that they can't be accused of staying quiet. But there's nothing on the form about having a haunted house. There is no disclosure on any contract in the world about whether your house is infested by ghosts. Okay? So, let's see. And coincidence, but you know, Alec Baldwin was in Beetlejuice, right? His brother Stephen Baldwin lives in this town. Absolutely worthless fact, but worthless fact, okay? So, I looked this up, yes. So, before we go too far, I have to commend the judge because he's a very good pen. He has a very good knack of using expressions that sound good. So I'll just list them. Phantasmal reputation, ghost of a chance, spirit of equity, elusive if not ephemeral, my favorite. Who are you going to call? Yes. Who's a Ghostbuster fan? I was, yes. Okay. A hobgoblin which we exorcised from the body of legal precedent and laid quietly to rest. Unearthed property's ghoulish reputation. And I think that was it. Okay. So he uses all this very colorful language. But the case itself is simple and the judgment is wrong. So everyone understand this. The court got it totally wrong. I think the dissent in 2 sentences summed up the issue quite well. So let's go, Josh. Josh, what happened in this case? What were the facts other than the haunted revolutionary soldiers?
I guess they complained, essentially saying that they didn't tell them about...
Whoa. Give me the facts. Start from the beginning.
So he discovered that the house was reputed to be possessed by poltergeists.
How did anyone know that this house was purportedly...
So there were like news stories and things like that.
Who put those news stories out?
The seller.
Okay, the seller. So here's what happened, right? The seller, Ackley, she made money by selling haunted tours, right? She gave all these newspaper interviews saying, my house is haunted, come give me money, come give me attention, right? Was it haunted? Who the heck knows, right? People are frauds, you know, psychics, fortune tellers, whatever. Maybe they're real, maybe they're not. I don't really care here, right? But Ms. Ackley told everyone in the world this house was haunted except for
the buyer.
The buyer. Okay? Jack, did the buyer have any indication that the house was haunted?
No.
Was there any way the buyer could have determined the house was haunted?
No, they weren't found there, so no.
Yeah, and that's an important point, right? And I'm not sure if this actually works the same way today. Today we have Google. And if I want to learn about a property, I'm going to Google it. And you're damn straight there's going to come up an indication that the house is haunted, right? A blog for a haunted house, right? That didn't exist in the 1980s, right? So is there any reasonable duty that a person could undertake to ascertain if the house is haunted? No. Right. I mean, basically, you can like call like Beetlejuice, you know, or like, you know, Ghostbusters come in, but that's not real. That's fake, right? This case sounds like it's from like the movie, right? So the court says that there was no way to find out. Now, Jackson, you're a skeptic, right?
Yes.
You're a skeptic for now. Can a house actually be haunted?
I'm a skeptic.
Yeah, be a skeptic for a minute. Does that bother the court? Does it trouble the court that we can't prove that house is haunted, right? Why not? No. Why does the court even work under the presumption that the house is haunted?
Well, I think he had a lot of fun doing it.
I know he had, yeah, I know he had fun doing it, but why do you think that he said it? How could the court conclude that the house is haunted as a matter of law? Why?
As a matter of law.
Yeah, I'm giving you a hint, yeah. Notice my questions are leading in the right direction. That's why they're asked. Remember the doctrine of estoppel? What's estoppel? No. Brendan, what's this? Why can the court here assume that the house is actually haunted as a matter of law?
Because the seller said it once.
Yeah. How would estoppel apply here? Estoppel doesn't just mean reliance. Have you ever heard it used in other terms? No?
Judicial? I just originally.
No?
She was stopped from trying to say that it wasn't haunted because she had taken it upon herself to try to make money off the fact that it was haunted and disseminated that
Yeah. Estoppel doesn't just mean unjust enrichment. It also means if you take a position, you're bound to it. She's relying on her past position, if you will. So the word that Catherine used, estopped. Anyone ever heard the word estopped? Estopped is a verb which means it's spelled like this. It's like stopped. It's a weird word. Estopped. It basically means you took a position before and you're bound to it. So whether or not the house was actually haunted doesn't matter. But the fact that Miss Ackley was so intent on telling everyone with a newspaper that her house was haunted means she was estopped. So as a matter of law, the house is haunted. Whatever, right? But anyway, it's actually not a crazy dispute because basically they had to acknowledge it. Okay. Sorry. This number keeps calling me. Okay, so we have now the holding that the house is haunted as a matter of law. Now, is that Will? So to reiterate a question before, did the buyer ever ask if the house was haunted?
No, he had no reason to.
So did the seller ever lie and say, you know what, this house is not haunted? No. So what do we have here? A case of nonfeasance or malfeasance?
Nonfeasance.
Yes. Why is this nonfeasance?
Because don't ask, don't tell. He didn't ask.
Yeah, perfect. Yeah, don't ask, don't tell. That's a way of looking at it, right? He never asked if it was haunted. Therefore, under the common law, there's no duty to disclose it. Well, why is that not the end of the case? Shouldn't that be the end of the case? There's no duty to disclose? Done.
They say that, I mean, there is no duty to disclose if that is something that could be found out.
Say that again. I think you're in the right track. Say it one more time.
Like, the buyer couldn't have found that out by just the normal walking through the house looking at it. Like, it's nothing that.
But isn't that true of everything, right? If you're not under a duty to disclose, let's use I said to Eduardo a minute ago, you know, the leaky roof, right? You can't tell if a roof leaks until the next storm, right? But if he stayed quiet under the common law, then he's okay. How come here the failure to say anything, you know, resulted in some sort of liability. Why couldn't they just apply the common law doctrine here? The New York court apply the common law doctrine here?
I looked at the doctrine of caveat emptor.
Good. Oh, that's my next question. Perfect. What is caveat emptor? What does it mean? Caveat emptor. What does caveat emptor mean? The phrase. Means buyer beware. Caveat emptor means buyer beware. So what does that mean, Spencer?
The buyer has a duty to assess the fitness of what he's buying.
Right, and if the buyer doesn't do a good enough job looking around,
Then so well.
too bad, right? So if the buyer doesn't go and inspect the roof and, you know, pour a little water droplets, see if it leaks, right? Is that whose problem is that? Exactly. Okay. So the common law duty is buyer beware. Now, one of the themes which we have in this class, and I said it involves New Jersey courts, I'll throw New York in the loop, is abandoning common law doctrines, right? Jeffrey, why do you think the court here was willing to perhaps revisit this caveat emptor doctrine?
Because, as Will kind of pointed out earlier, it wasn't something that was really obvious. You know, it's not a reasonable person wouldn't.
Oh, no. You're right, but just more generally, right? Why do you think the courts in New York may be unfriendly towards this caveat emptor doctrine? What about it?
They don't like it. It's being
Why? What about it that they don't like?
it's unfair.
Unfair, right? This is the word that will provide the answer to every single question I ask, right? If I ever ask, why is the court abandoning the common law doctrine? What's the answer?
Unfair.
It's unfair. You can just write down in your margin, like of your book, right? Big letters on the cover of your book, unfair. In this class, whenever you see a court getting rid of a common law doctrine that's exists for 500 years, it's not fair, right? And I mean, Nali, do you think caveat emptor in this case is fair?
I don't think so.
Why not?
Because you know whether the house is haunted, it cannot be discovered by the buyer, and this situation may entail value of the house. So it's not fair.
Okay, so it's not fair, right?
Yeah.
What about from the seller's perspective, right? Why shouldn't caveat emptor benefit the seller? Right. In other words, let me ask a question like this: what's the cost of getting rid of the caveat emptor doctrine? What's the cost of getting rid of this doctrine?
This doctrine is your equity.
Equity.
Yeah.
Mhm. That's good. No, that's good.
No practical process.
Right. So in other words, right, if we get rid of caveat emptor, it benefits the buyer a lot. If we get rid of caveat emptor, what's the cost of the seller? Very small. At worst, right, what's the cost of the seller? His house will get less money, right? If the seller actually discloses it's haunted, he'll have to get a lower purchase price. Maybe some people want a haunted house. I don't know. Right? So effectively what the majority says is like this, right? This doctrine, this caveat emptor doctrine, it's really unfair to the buyer, and it's marginally better for the seller. We should not be so rigid in sticking to this, you know, this 100-year-old common doctrine, right? If the owner bragged to everyone that it was haunted, why is it such a big deal to make the owner tell the person it matters to, the buyer of the house? Also, the court made a big deal of the fact that the condition was created by the seller, right? The seller knew about this and impacts the value of the house. And because it impacts the value of the house, The majority says there's a duty to disclose it. Okay. So the holding, right? What's the holding? From New York? You have a duty to disclose haunted houses. Everyone's writing this down like I was serious, right? No, but basically, if there's some condition which cannot be disclosed, the seller knows about it, it should be revealed. Okay? This is a rejection of the common law doctrine, right? This moves in a very different direction. And as we'll see in the next case, the Florida case, the trend is to basically get rid of caveat emptor, or at least significantly weaken it, for the reasons we mentioned a moment ago. It's often unfair. Okay. All right, any question about the ghost case? It's a fun read. It's a great read. But the law, you know, leaves a little bit to be desired. Very spirited dissent, though.
Short, wasn't it?
What?
Wasn't it real short?
Yeah. Yeah, so the dissent was basically 2 sentences, right? And what did the dissent say? Catherine, you're up next, right? What did the dissent say?
I don't have it in my notes. I just remember it was very short, and it was whoever the judge was just disagreed entirely.
Basically, she said, if we're going to get rid of caveat emptor, we should do it in a real case, right? Maybe with a leaking roof, not the haunted house, right? Something that actually matters. Because think about it, Catherine. You're an attorney working in New York, right? What the heck is the rule in this case, right? Going forward, how are you going to apply this case for the next one, right? What happens if there's a situation where, I don't know, there's a leaky roof, right? And it's something which you could not determine until there's actually a storm. Under this precedent, does the seller have to disclose it?
I guess not if it only applies to haunted houses.
See, but that's the thing, right? The haunting is very nebulous and phantasmagorical, I might say, right? Of how it actually appears. And it doesn't actually say what applies. It's a lot of factors, but it's not clear. Yes, sir.
I mean, the justice had said it's a matter of law the house is haunted. Therefore, there's a defect in the house that the seller knows about. It's not common to a typical buyer. So I
Right.
don't see how that would easily be. That would easily parallel other cases where you have a defect that's known to the seller,
Mhm.
the buyer doesn't necessarily know, or a reasonable buyer wouldn't.
Yeah, I think you're holding the case a lot clearer when the judge actually wrote, though. Yeah, I mean, what you said is a good holding. I think it's a good summary, but the opinion actually fudges around the margins whether it's that clear. And it kind of lists different factors, right? So I think it'll be an open question of how much of a defect or how difficult it is to determine, right? So the good thing about caveat emptor, it's easy, right? It's very easy to apply. Once you go away from caveat emptor, the question becomes, how big of a deal must something be before it has to be disclosed? Right? How much does that have to affect the value of the house if you have to reveal it? Right? So then there's a lot of other questions at the margin. Other questions? Yes.
I have a question. It's not the ghost. It's someone that abnormally or maybe some murder or something. It's the same holding like the ghost.
Say your question one more time, please.
Oh, sorry.
That's okay.
My question is, it's not the ghost. It's just maybe someone once died in a house
Okay, good.
abnormally, or once there was a murder.
Okay, so you're asking if there was a murder in the house before, right?
Yeah,
Does that diminish the value of the house?
yeah. So it's not the ghost. It's
Right.
not like the ghost. But maybe someone died in the house abnormally. So it's the same situation.
Right. So the question is, what happens at reputational cost? Right. What happens if there's a house that was known that there was a murder in the house many years ago? Right. Has that affect the purchase price? So I think I have it here. I can't remember.
Look at the disclosure.
So there's I linked it to the bottom, but there are a number of cases where that exact issue comes up. Yeah, and that's exactly right. I linked to a couple more recent cases, right? Generally speaking, the mere fact that the house may be stigmatized, right, that doesn't make it a material defect that must be disclosed. There was a case from the Pennsylvania Supreme Court about a year or two ago discussing this. It was an ABA journal. You can link to them right there. But generally speaking, the fact that there was murder before does not become a material defect. So the New York case is out of the mainstream, right? It usually reputation, things about the house's image are not bound to be disclosed. There's actually a case, I don't know if you read about in Galveston. Anyone know this one? Where there was a house where there was like a many murders in one house. And then they demolished the house and they built like condos to rent on top of it. And then someone was renting one. He tried to have his lease canceled because he realized it was on top of a murder site. And the court basically said, too bad. Which I think is probably the right decision. Especially if they demolish the house, maybe they have to like say some prayers and spells over the soil. I don't know.
I'm just saying.
I got in trouble for this before, so I'm not gonna say anything.
All right.
I got in trouble. I'm not gonna say anything about this. All right. Any other question with the ghost case? Okay. All right. Let's go on to the last case, Johnson v. Davis. So this case concerns, excuse me, this case concerns what are known as latent defects. Is that Brad? Brad, what is a latent defect?
Latent defect would be one that is not readily apparent.
Good, right? A latent defect is something that's not readily visible. And the classic example is a leaky roof, right? Why is a leaky roof not readily visible?
Unless it's raining.
Exactly, right? Until it starts pouring, you have no idea if the roof is leaky. So I'll give you an example. Well,
that's kind of true, but I would say that's not.
Well, I'll give you an example.
If you have a good public adjuster look at it, you know if it's been leaky.
But that's the point, though. You don't always need to have a good public adjuster, right? You should be able to have defects that are readily visible, right? Yeah. A latent defect, something that's not. You could find out for sure, but it's not readily, easily visible, right? Stop finding the hypo. What about a cracked foundation? The cement underneath your house is cracked, and you can't even see it because it's underneath the house. Is that latent?
Ooh, man, I'm from Southeast Texas, so sometimes, but not always.
Okay, so
how that nasty the crack is, because I've seen them get pretty bad there.
Again, this is not is it feasible to determine if you're really gifted? Is it readily apparent, right?
Not generally.
Yeah, not generally. Good. So if it's not generally apparent, it's latent. So, I mean, I once moved into an apartment, and within 5 minutes when I moved in, a tropical storm hit, and all the windows and things started flooding, like within 5 minutes of me getting in there. That was really, really bad. So I had to disclose that on my little, moving form. But sometimes you don't know this stuff until you've been there for a while. You might have been there for a year, a month, and you can't no longer get out of your contract. Yeah.
It happened to me today. I woke up this morning and had like puddles in my bathroom. The ceiling had, I guess, overnight or over the course of the past year that I've lived there, something above me, a cracked pipe or something, it's busted and there's water all over the place.
Big problems?
Oh, yeah.
Yeah. It's problematic, right? So
yeah.
The reason why, one at a time. No crosstalk. So the reason why latent defects are problematic is that it's almost impossible, with your experience accepted, for the buyer to be aware of it, right? So a number of jurisdictions have started to say that you have a duty to disclose latent defects. And if you notice on that long form, that long contract we did last class, there were things about like termites and foundation and lead paint, right? These are things which are not readily visible, right? If there's a crack in your foundation, you're not going to know. If there are termites, you may not know until your thing starts crumbling apart. Maybe the seller doesn't even know, right? But under the common law, the only problem was the malfeasance. You have to lie. If you lie about it, you're in trouble. If you stay quiet and you can skate by, you're fine. All right, so Tyler, what happens in this case? And by the way, the Florida Supreme Court of Florida, the nickname is Scofflaw. Scofflaw, Supreme Court of Florida. Like a person who breaks the law says scofflaw. Thanks. Well, one of you did. Yeah, go for it.
So the Davises enter a contract to buy the Johnson's home. It's for over $300,000. They put a deposit down for about $30,000. And the Johnsons don't, or they kind of misrepresent that the
Good.
roof is fine.
And this is important, right? Were they quiet about the leaky roof?
No.
What did they do?
said everything's great.
What do we call that?
I think they call it affirmative representation.
We call it lying also, right? They lied. Right? Yeah, you're exactly right. It's called an affirmative misrepresentation. Well, you can call it lying, or you can call it malfeasance, right? They basically lied and they said, yeah, everything's fine. Don't worry about it. Everything's cool. Okay? So isn't this an easy case, right? Even under the common law, if you lie about it, what happens?
It should go under malfeasance.
And then what do we do to the contract?
They can sue to rescind the contract.
Exactly, right? So this case isn't problematic at all, right? This case has been very simple. So why, Alejandro, why was this case even in your book, right? Shouldn't this have been a straight up application of they lied, it was malfeasance, so you rescind the contract? What did the court go on to do?
I think they want to get rid of that.
Yeah.
For Louis.
Exactly right. So the Supreme Court of Florida said, we'll hold first, very easy, that there was malfeasance here. We can rescind the contract. But we need to revisit this caveat emptor doctrine, right? Alejandro, what do they say about caveat emptor? What's the problem?
They didn't like that the seller could like hide behind it
Yeah.
and induce like they said false belief and stuff like that to the buyer.
Yeah, and there's this idea of inducing false reliance, right? If the buyer can just sit there and be quiet and say nothing, in the case of the ghost, right, say nothing, they can put they can put the new owner in a very tough position because basically they're stuck with something they didn't know about it. And this is especially true where the defect is material, right? Is that Greg?
Yes.
Greg, what does it mean for a defect be material?
Where it alters the property value.
Exactly, right? We're not talking about something minor, right? A material defect is something that substantially, materially alters the value of the property, right? If something changes the value of the property, it's a material defect. And the court says you should not be able to withhold those sorts of material defects. Okay, Chase. Now, how does the Supreme Court of a state go about eliminating a common law doctrine that's been around for like 500 years? Like, what's the thought process of getting rid of an old common law doctrine? How's the court reason?
Oh, well, they cite that more recent cases
Good.
have they've extended the doctrine of caveat emptor.
Exactly. So this is a very common tack of courts, right? When they want to abandon a common law doctrine, they start looking to other courts and say, well, look, California did this, and New Jersey did this, and New York did this. The direction of the law is changing, right? Chase, what do you think of that? I mean, what does that mean? I mean, when a court is basically looking to the courts and saying, oh, our New Jersey or our, Florida law is changing, what are they doing there?
Well, if you really want to know, I think they're just justifying bench legislation.
They're justifying bench legislation. What does that mean? Go on.
They're finding a means and an end to create a new law to.
Is there any legislation here, though?
Well, no.
What are we dealing with? Is it a statute?
No.
What are we dealing with here?
Case law.
It's common law, right?
They're common law.
And who develops the common law?
Cases. Courts.
Yeah. So usually you be on track, right? And this, I was kind of baiting him a little bit in this one. It worked just exactly to plan, right? Usually when judges start making stuff, we say, oh, wow, they're making law and the legislating for the bench, all these other hyperbole, right? But this is a common law case. And who controls the common law?
The courts.
The courts, right? But that's not the entire answer, right? Is that John or Tyler? Tyler. So Tyler in quotes. I got my fancy new type seating chart. So I don't have to look at your inscrutable handwritings, which I can't read anymore. Perfect, yes. So Tyler, let me ask you this question. Generally speaking, how did the common law evolve?
Case after case.
Gradually, right? A little bit at a time. Did it ever happen the courts would just abandon the doctrine altogether in a common law evolution? Well, how do you think if you're a common law judge, right? Back in the 1800s somewhere, right? And you have a case that you don't like their outcome, and you think this doctrine's not fair. How would judges usually go about changing the common law? Actually, this is a bigger meta discussion probably. It's worth having.
I guess it would be, instead of get rid of it altogether, maybe gradually.
Yeah, incrementally, right? So imagine like this, right? Imagine the original doctrine was caveat emptor, period, right? You had no duty to disclose anything. But then you might be able to say, well, you know what? You only have a duty to disclose a material defect, right? And then you say, you only have a duty to disclose material defect if the seller knew about it, right? And to incrementally keep adding one layer on top to the next. That's how the common law worked. But what happened the last 30 to 40 years is, right, we'll just dump caveat emptor altogether because California's doing it and they're cool. Basically, I mean, that's what they're saying. Like, the other states are doing it. They're cool. Why can't we? And they say that this should be the law of Florida. Okay? So with this, the court basically eliminated the distinction between malfeasance and nonfeasance, right? If there's a latent defect and the seller knows about it, he is obligated to say something. No longer can sellers cheat and just try and get a higher purchase price by not disclosing these serious latent defects. Okay. All right. Any questions? No? Have a nice weekend.